Section 25 of the Labor Act 11 of 2007. This section deals with compassionate leave. In terms of this section, an employee is during each period of 12 months of continuous employment entitled to 5 working days compassionate leave with fully paid remuneration. An employee is entitled to compassionate leave if there is a death or serious illness in the family. So only when there is death or serious illness in the family. So the minister must prescribe the form and manner in which compassionate leave may be applied for by an employee and any other information that may be required to support the application. Now, the minister has prescribed such form in the Labor General Regulations. Now, in terms of Regulation 5 of these regulations, the minister has prescribed that an application for compassionate leave in terms of Section 25 of the Act must be made on a form determined by the employer, but the form must substantially correspond to Form LS 3 set out in Annexure 2. So the employer must come up with their own form, but it must comply with the form and requirements of form provided for by the minister in Annexure 2. The minister has also prescribed in these regulations that the application for compassionate leave must be made either before the applicant takes leave or, if not possible, immediately upon applicant's return to work. These regulations also indicate that an application for compassionate leave must be accompanied by a death certificate of the deceased in case of death, or a medical certificate in case of serious illness, or an affidavit on the employee testifying to the death or serious illness, or in all cases such other evidence or death or illness such other evidence of death or illness as may be acceptable to the employer. If the applicant cannot make the application before going on leave, the applicant must make reasonable effort to notify the employer of his or her absence for compassionate reasons and the intended duration thereof. Now, those are the information that are prescribed by the minister in terms of Section 25(3). Now, to continue with Section 25, compassionate leave does not form part of annual leave or sick or maternity leave. Compassionate leave does not entitle the employee to any additional remuneration or on termination of employment. And compassionate leave, if not used during the period referred to in subsection 1, meaning that leave cycle prescribed, then compassionate leave lapses at the end of that period. Now, for purposes of this section, family, meaning compassionate family for which compassionate leave may be taken, means a child, including a child adopted in terms of any law, custom, or tradition, a spouse, parent, grandparent, brother or sister of the employee, or father-in-law or mother-in-law of the employee. Now, those are the only family members for which compassionate leave may be taken. Now, there is an interesting South African case, which is Toyota South Africa Motors versus Nomsa Obonjilo. Now, in that case, the court had actually decided otherwise in terms of what constitutes family for purposes of compassionate leave. Now, in this case, the employee was charged for dishonesty in that during May 2023, May 2013, July 2014, and February 2015, he had provided false information about his relationship to the deceased, which resulted in him receiving compassionate leave payment for which he did not qualify. Now, in that case, The leave form for 2013 and the leave form for 2014 reflected that the deceased was the mother of the employee. And the one for 2015 reflected that the deceased was a son for the employee. Now, explained in Western terms. Now, the son was actually Mr. Njilo, the employee's late brother's son. In other words, the nephew. And the mother, or the two mothers, were actually his late father's second wife and then his aunt. So it was his aunt and his stepmother that he actually referred to as his mothers. And then it was his nephew that he referred to as his son in the compassionate leave application form. So now the matter went for arbitration, and the arbitrator actually accepted Mr. Njilo's version, which is, in broad term, is that he just knew from a colleague that one can apply for leave when a family member dies. He had been unaware of the intricacies of the compassionate leave policy, particularly that it did not cover people he regarded in Zulu culture as his immediate family, mother and son. He said in Zulu culture, a man assumes responsibility for his deceased father's wives and the children of his deceased brother. In any event, he had not hidden the relationship between him and the deceased when he approached his Zulu-speaking group leaders to apply for leave. He was traditional and would have used cultural names to describe the relationships. Example, Mamkane for his father's wife, and so on. In conclusion, when the arbitrator's award was taken for appeal, or yes, when it was taken for, not for appeal, but for review, the court actually concluded that it could not say in totality that there was evidence that the arbitrator actually committed any reviewable irregularities in finding in favor of the employee in her assessment of the evidence or her conduct of the proceedings, and then that award was actually upheld, or rather that it stood. So in this case, I find it quite interesting because now the father, the mother, especially in our culture, in our African culture, it sort of doesn't really make a lot of sense. It's a bit of a Western concept, the description of family in our Labor Act. And I like this case because in this case, our African version of what constitutes family was actually brought out, and I just applaud the fact that the arbitrator actually awarded the employee, and that even at review the labor court actually upheld the award that was given by the arbitrator. Maybe it's something that Namibia can also maybe consider in terms of trying to make or to amend section 25 subsection 5 to just also Africanize it. I don't know what you guys think, but we can discuss in comments below. If you have any Namibian case also where this issue was raised, maybe where somebody referred to the niece as her daughter instead of niece, because we do not have those concepts mostly in Africa, please do share that case, because it's a debate that we can actually have, and it's something, a contribution that we can actually make. If there's anybody that probably wants us to write an article, we can consider that as well. But yeah, I'm just saying it's an interesting topic to actually engage ourselves in as young professionals.